I want to say it's a real honor to be here today, and I will get to that. But what I really want to say is people have shown their commitment to justice by demonstrating, organizing, running for office, even engaging in civil disobedience. But to be up this early on a Saturday morning shows how deeply committed you are, although when you have a panel like this, it is very much worth having that extra cup of coffee and being here. And I also want to say I'm deeply honored to be here because I think the ACS is one of the most essential organizations in our country right now, that all of you are working again so that we can again bend the arc of history toward justice in our country. And I am not biased, even though our son is a first year at UVA and is a member of ACS. And I'm proud I'm proud he's a law student, but I'm very proud that he's a member of this great organization. I'm probably going to encourage people here. I love the old tradition of heckling in public events. And one of my favorite heckling stories is about Al Smith when he was running for governor of New York. Somebody got up in the back of the room and said, "Tell him all you know, Al, it won't take long." And Al Smith was very clever, he looked back at the guy and said, "I'll tell him all we both know, and it won't take longer." And in this case, I am very honored to be moderating a panel, every one of whom knows way more than I do, and so that's why I am very happy that I am the moderator here today. I want to just say a couple things. First, and I think I forgot to do it myself, please silence your cell phones. Second, the Twitter tag here, and you are free to tweet. We believe all of us up here in free speech. The hashtag is hashtag ACS 2019. This is very important for some of you. If you are seeking continuing legal education credit for this session, the QR code on your name tag must be scanned at the beginning of the session by one of our volunteers, so you can get that done. I don't know how many of you need that, but it sounds important to me, so please go ahead.
1984.
Right, yeah, except you got no credit in 1984. And lastly, there will be cards circulating for questions, and please feel free to ask the most challenging ones. We're not going to. We are not editing them to leave out controversies. So please feel free. I'm going to try to get to the questions as early as possible and intersperse them with my own questions. So just get them on up here as early as you want. I suppose it would be nice to hear what the folks had to say, at least on the first round first. But given that this is a panel on political reform and on all the work we are going to need to do, I will make one part of the statement, I hope after January 20th, 2021, you may have some questions in mind already, but again, thank you all for being here. So let me briefly introduce the panel. Stuart Gerson, I should begin because he began that way with me, is an anti-Trump conservative. He wanted that to be known, and he's proud of it. He's a member of the firm. Yeah, go ahead. If we could. Yeah, it may be the one time when Stuart is in complete agreement with a large number of members of the panel. He is a member of the firm Epstein Becker Green, a former Department of Justice official. He served as Assistant Attorney General for the Civil Division during President George H.W. Bush's administration, and acting Attorney General of the United States during the early part of the Clinton administration. Chara Torres Spalaski. I tried, I practiced, and I failed, is the Leroy Highbaugh Senior Research Chair and Professor of Law at Stetson University College of Law, where she teaches courses on election law and constitutional law, two of my wife's favorite classes in law school, by the way. I love lawyers, I very clearly. Walter Schaub, I think so all of you know his work. He is the senior advisor to Citizens for Responsibility and Ethics in Washington, known as CREW, and previously served as director of the U.S. Office of Government Ethics. Elliot Williams is a principal at the Rabin Group's Government Affairs Practice Group and is a former senior political appointee during the Obama administration. He served as Deputy Assistant Attorney General for Legislative Affairs at the Department of Justice and Assistant Director of Legislative Affairs at the U.S. Immigration and Customs Enforcement. Joseph O'Connell is the Adelbert H. Sweet Professor of Law at Stanford Law School, and her research and teaching focuses on administrative law and federal bureaucracy. And Shanlin Wu is a named partner at Wu Grochowski and is a former federal prosecutor whose government service includes service as counsel to Attorney General Janet Reno. So I'm going to start with Ann O'Connell. I warned her about this already. President Trump has used, and just to be transparent about it, I actually had a careful consultation with all our panelists. I think one of the jobs of a moderator is to allow panelists to put on the table the things they believe are most important. So my questions, I do not want to pretend that I brilliantly conceived of all these questions myself. Thank you for all your help in doing that. President Trump has used the 1998 Federal Vacancies Reform Act and other statutes to circumvent the traditional appointments process. The most important title in government right now is acting, I think. On the other hand, recent administrations demonstrate that the political appointments process consumes considerable time. That's very diplomatic. And the president's party may not control the Senate. Even before this administration, we really did need reforms in the way people in the government were named and confirmed. How would you balance the goals of the process, and where do we need to reform it? And thank you for joining us this morning.
Thank you. I should start by saying that I'm working on some institutional projects related to acting officials and delegated authority, but what I say today is entirely in my personal capacity. So just to start, the modern appointment system is broken. So if you look at nominations to federal agencies from the start of the Reagan administration to the end of Obama's administration, over 1 in 5 of those nominations didn't get confirmed. It wasn't that they were voted down, just a tiny number. A few were withdrawn, but most were returned by the Senate to the president. And that figure has gotten worse over time. So in President Obama's administration, 1 in 3 agency nominations were returned to the White House or withdrawn. And so for those nominations that succeed, sometimes on the second or third go-around, in Reagan's administration, it took about 2 months for one of these successful nominations to get confirmed. In President Obama's administration, it was about 4 months. And if you look overall at Senate-confirmed positions in executive agencies like the EPA or cabinet departments, about 20% of the time, there's not a Senate-confirmed or recess appointee in the job. So if you want the government to function, right, and some do not. I mean, if you look at Justice Scalia's opinion in the recess appointments case, Noel Canning, that the Constitution, according to Justice Scalia, did not include a kind of workability assumption. But if you want the government to function, these acting officials play a critical role. On the other hand, we can see in this administration some circumventing of the laws in place regarding temporary leadership in federal agencies. Let me give you one figure. So if you look under the Federal Vacancies Reform Act and other statutes, and you consider just cabinet secretaries, okay, the very heads of what are now 15 cabinet departments, in 8 years of President George W. Bush's administration, there were 22 acting cabinet secretaries for at least 24 hours. Okay, the early morning hours of January 20th, I've excluded. In the 8 years of President Obama's administration, we have 23 acting cabinet secretaries. We're not even at the 2.5-year mark in President Trump's administration, and we've had 24 acting cabinet secretaries. So how do you balance a kind of broken appointment system, a desire to have the government function in these gaps of Senate-confirmed leadership, but also not have circumventing of rules in place? Is I think you can make some changes to the Federal Vacancies Reform Act of 1998. Now, when Matthew Whitaker was named acting Attorney General, many on the left wanted to toss out the Vacancies Act of 1998. I'm a believer in the Vacancies Act of 1998, but I would put forth 3 reforms. Number 1, who can be an acting official? So under the 1998 Act, there are 3 categories. Number 1, the first assistant. So when the Attorney General is not available, the deputy, the first assistant, could step in. The second category is someone who's been Senate confirmed, whether in that agency or in another agency. So there was some controversy regarding this in the Consumer Financial Protection Bureau, assuming that the Vacancies Act applied when Mick Mulvaney gets taken because he's Senate confirmed in OMB and then gets put in to the Consumer Financial Protection Bureau. And then there's a third category, which generated a lot of controversy with Matthew Whitaker as acting Attorney General, again, assuming that the Vacancies Act applied there. And that's you can take someone who's not Senate confirmed, who's not the first assistant, who's been working in the agency for at least 90 days in the year preceding the vacancy. So what would be my first reform would be to modify but not eliminate that third category. So you want to decrease the number of times that political people who have not been Senate confirmed get picked out like Matthew Whitaker. I would change the 90 days to 5 years preceding the vacancy, because what has happened in the past is you can draw from senior careerists with considerable expertise in federal agencies to come in, especially at the start of administrations where you may not have other Senate confirmed people to draw from, and put them in these critical months in an acting capacity. Second reform, under the 1998 Vacancies Act, these officials can stay a really long time. In the first year, 300 days. After that, 210 days, plus the pendency of 2 nominations, and 210 days after each of those 2 nominations if they're returned to the White House. So you can get something approximating 2 years under the Vacancies Act. Many have called for the elimination of that second nomination. But go back to what I said at the start. If 1 in 3 agency nominations are getting returned to the White House in President Obama's administration, particularly in the years when the same party did not control the White House and the Senate, is I think you want 2 pending nominations, but to decrease the time not when a nomination is pending. So I would allow 2 pending nominations and 210 days total. So that 210 days would have to cover kind of coming up with nominations and the gaps in between nominations, but we could decrease the amount of time that acting officials are serving. And just a note empirically, right, that currently under the 1998 Vacancies Act, the longest serving acting official was actually in President Obama's administration, was Rebecca Blank at the Commerce Department. It's actually the only time under the 1998 Vacancies Act where we've actually had neither a confirmed, recess, or acting official, like after her time limits ran out. There was actually no one heading the Commerce Department for a few months. But the periods in this administration, right now, President Trump has 3 of the top 10 acting cabinet secretary lengths under the 1998 Act. So the second one is decreasing the amount of time. The third and final reform that I'll discuss here, I have other ideas as well, has to do with end runs around the Senate confirmation process. And many are focused on the Vacancies Act and the people that the president can choose. Oh, they're not Senate confirmed. Oh, and how long they can serve through these pending nominations. But the biggest end run around the Senate confirmation process is not the acting title, it's delegation. So what do I mean by that? Is once the time limits run out for the Vacancies Act, anything that is not delegated exclusively to the position, and that turns out to be a lot of stuff, can be delegated down to other people in the agencies. Now, I think that there's something there for appointments clause challenges with regard to delegations down, depending on how long these employees are carrying out delegated functions. But what you have, you can go to any agency website right now, the time limits had run out in many cases, and what you're gonna see is someone, a title, and it then says performing the functions and duties of whatever the vacant office is. And that's the biggest end run because there are no time limits on those delegations. In many agencies, those delegations are not transparent. And so my third reform would be to spend more attention by Congress on what duties and functions should actually be exclusive to the Senate confirmed roles. And for those that you're gonna allow to delegate down to allow our modern government to function, there should at least be much more transparency about those delegations. So I'm a believer in the Act with some reforms because sadly we have a broken appointment system, but don't give up on actings.
Thank you so much. I want to ask just a real quick follow-up because I want to get everybody else in. And I may ask this question, a version of this question, everyone, because every era produces a set of problems which we then respond to. We pass reforms, we overreact to those problems, and then we create a series of other problems on the other side. And a few years ago, my colleague Bill Galston and I did a paper together on the confirmation process. That was when we were looking at a very different set of problems. Struck us that the whole confirmation process has become a gargantuan problem. And paradoxically, if you really want congressional engagement, Congress is getting, it's so difficult to get through. You could probably write an autobiography, a pretty good one, in the time it now takes you to fill out a questionnaire that just gets longer and longer and longer. Just very, very briefly, your view on reforming the way Congress deals with this on the other end.
Yeah, so I was part of that group with you and Bill Galston, and it
yes,
some of my empirical work, but it contributed actually to the streamlining, Presidential Appointment and Streamlining Act, which actually cut the confirmation requirement in 2012 for about 160 positions. So let me say one thing overall, and there are a couple quick things. Many commentators and good government commissions like the Volcker Commission have called repeatedly for the cutting of confirmation from a number of positions. But we have a different group that has been advocating, saying, well, these actings are terrible. And those views are actually in tension because in some sense, what Congress has refused to do, right, cutting the confirmation requirement, is being done functionally by the use of actings. And so I'm kind of writing about this, but kind of sitting with that tension is that kind of by not putting up nominations and using the Vacancies Act, the White House, in essence, has cut the confirmation requirement out. And there's obviously, that there has benefits to that and there are costs to that. But in terms of some changes to the confirmation process, since you obviously can't eliminate it for the very top positions, as EJ and Bill and others in this working group advocated, we need to streamline the disclosure and vetting process, that each Senate committee has different procedures for nominees. Maybe second, we could impose some time limits. The Senate could impose on itself some time limits for how long they will allow a kind of nomination to percolate before they get to a vote. So maybe it's been proposed that national security and other positions, the Senate would allow only 60 or 90 days, and then they would force a vote on those nominations.
Thank you so much. We're trying to make it easier for all you young people to get confirmed when your time comes to serve in our government. Elliot has actually, this is a classic unintended consequences question. Elliot wanted to talk about the creation of the Department of Homeland Security, which has raised a lot of questions. Just a few questions on that. Has the structure of our immigration system consolidated too much power in the White House as a result of this? What effects has that structure had, not just on how we see immigration, but on the management of government? You also would like to talk about the problems with creating an immigration czar. And then my question at the end is, there seemed to be, in the creation of the Department of Homeland Security, this is kind of the Department of Hodgepodge. And it was really quite remarkable to me that how this got created. So I think this is a cautionary tale for us going forward on any of our other reforms.
And I should give a trigger warning to the audience that my comments largely are not about Donald Trump, which
that's good.
Boo, I know, sorry, but no, but it's true, because this to me is a far bigger problem than Donald Trump. And I actually think when it comes to a lot of these problems on immigration, Donald Trump is the symptom, not the problem, and is capitalizing certainly on a structure of an immigration system that has allowed and almost enabled him and his folks to behave a certain way. But let's sort of broadly and more philosophically, right? When you talk to undergrads, when you talk to people who are sort of not as trained in government, I think they don't really understand inherently the concept that all the structure of government is a reflection of the philosophical values of the people who crafted government at the time they did. A bicameral legislature is just an idea. It doesn't have to be that way. As you saw, there was a whole panel on the size of the Supreme Court yesterday, or whether you call it packing or whatever else. But that's an idea. It just got put in philosophically by people, right? We decided, whoever the we, capital W, we, decades ago, that immigration was a matter of public safety. It was going to be thought of and conceived of in government as a public safety matter. And going back to prior to 9/11, so this is up until maybe around 2003, until the Homeland Security Act, immigration was under the Justice Department for the most part, broken up into two different agencies. 9/11 happened, and then the Department of Hodgepodge is created. And I've got the 9/11 Commission report here because I was reading 400-page reports before it was cool this year. But I think there's one sentence, there's many sentences in this, and you should take a look at it. But there's a sentence here, and this sums it up. It is elemental to border security to know who is coming into the country. That's an unremarkable point, right? Like, it is elemental to border security to know who's coming into the country. But that sentence has driven our entire approach to immigration, because we've chosen to put immigration into a Department of Homeland Security. And this gets back to this philosophical point I was making. And I'm going to make a purely descriptive point here. This is not normative at all. But you could make a far stronger case for our immigration apparatus to be in the Department of Labor. And here's why. Again, non-normative, just descriptive. Everyone virtually who comes to the United States is coming to work. That's not a remarkable point. And even folks who aren't coming as immigrants, so if you're talking about temporary guest worker visas and so on, where they haven't declared what's called immigrant intent, an intent to stay in the United States, they're coming here on visas to work. So virtually of the millions of folks, they're here to work, right? Now I understand, and it's a fair point, that there's always a public safety element and so on, but everybody's coming to work, so you could make an argument, so that's more just an illustrative example of where immigration as an apparatus could be put, and that's fine. So that's the sort of philosophical point. On the good government or the structure of government point, and this gets back to EJ's point about the Department of Hodgepodge, you read the report and it's fine. We all remember 9/11, a lot went down, and there was a rush, I think, to solve the problem and overcorrect the problem. And what ended up happening was the creation of a behemoth department of or maybe 22 different entities that just touched Homeland Security in some way. So right now, what you have is a cabinet department with an individual that oversees both the Secret Service and Customs and Border Protection, which, fine, they both touch security, the security of people, or customs enforcement. So crates and cargo screening is overseen by the same cabinet official who oversees, grandma's visa. That's a choice, but what I think ends up happening is the job is now too big for one person to oversee effectively. And it's not a knock on Napolitano or whoever is running the Department of Homeland Security now. It's not a knock on them, but it's a hard job to run effectively and do well when, given the sort of labor and political and moral or public safety, all of the different factors going into immigration, why is it there? Now, and I wrote a piece of sort of what triggered this in our going back, and this is the second time I've said trigger today, I'm gonna stop saying that word. But what sparked this in our email exchange was, I wrote a piece for CNN earlier in the year that said that part of why currently immigration is so politicized is that the structure of government has allowed the White House to sort of co-opt it and take it over. And I do think you could make an argument for giving immigration its own cabinet department. With some, so what could be done is you take back ICE, Customs and Border Protection, U.S. Customs and Immigration Enforcement, which are the three major immigration agencies, perhaps the Executive Office of Immigration Review, which is the litigators, out of the Justice Department, and put them in one accountable cabinet department under a cabinet secretary who is Senate confirmed. Now, it creates more government. I know many people don't feel great about that, but what we have now is a cabinet department that is overseen by, I think it's like 103 congressional committees, and that's just not good. And I think if we really are serious about keeping the public safe, but also being true to what immigration ought to mean to the country, but also being true to the Secret Service being managed in an effective way, or the Coast Guard being managed in an effective way. And all of these things getting the kind of direct day-to-day oversight and leadership, both from senior cabinet officials and Congress, you have to get immigration out. And that's, again, I don't think that's unique to Donald Trump. This is a problem we have in government. And of course, there will be some other event at some point that causes us to overcorrect this again. But in creating this behemoth agency, and if we were to run down the list of the 22, a lot of them have truly nothing to do with each other. They really, other than, they kind of touch public safety in some way. So there you go.
Thank you so much. It underscores an issue that again, we can't cover everything here, but I am fascinated by this question of how power in Congress is so dispersed that many agencies are subject to multiple committees, and that when somebody in this room becomes Speaker of the House, I think to make Congress actually more effective, to make oversight more effective, you need to consolidate some power and narrow the jurisdictions, except no one who has jurisdiction will ever want to give it up, and it's very tricky.
No, so 2 points there. One, that's absolutely right, and it's having run legislative affairs there, or helped run legislative affairs there, it's a mess, because it's what you have are, we would talk about the 103 or however many committees that would oversee. They're all fighting with each other for a sliver of, is it the Homeland Security Committee or the Judiciary Committee that oversees it? My former boss, the head of ICE, goes through both committees and has 2 confirmation hearings, which makes no sense whatsoever. So that could be made more efficient in general. The other point, and this is more peculiar to to the current administration. You like that? The idea of an immigration czar was designed to, I talk about this in the CNN piece, perhaps their heart was in the right place, because perhaps we should put all of the border stuff under someone's management and control. But what you end up having is someone who's totally unaccountable to Congress, who probably can't testify. Because if this person were brought in and we know that subpoenas don't work anymore, but if the person were brought in to testify, it's a White House official, so he probably, or she, could not, or at least would be outside of any sort of meaningful oversight from Congress. So it was a clever solution, and you got to pat them on the back for it, and maybe it'll happen. this borders are that they want to create. But that's part of the problem, and it's a symptom. Like I said, it's the symptom. So. Anyway.
So Ann and you will spearhead a ACS task force on congressional reform on top of all your other work here. Thank you. Stuart wrote the most awesome questions for me, so I'm not even going to try to pretend that I am editing them or make any changes. I just want to read a couple of them, and one in particular. You are a never-Trump conservative who is one of the lead counsels in the El Paso border wall litigation and a founder of Checks and Balances. Given those associations, do you believe that the fundamental rule of law problem occasioned by this president can somehow be resolved by remedial legislation? And then just to give it away, parentheses, I don't, but I'd submit that any genuine beneficial effect can only be achieved if Congress acts like the framers intended, and that goes for both parties. And then I'll just do two others that you wrote, and you can take it where you want to take it. Do you really think that the Justice Department shouldn't be reformed? I like the kind of negative phrasing of that question. It implies something, I'm not sure what. You'll tell us, but this is the best. He wrote, "You're so damned old that on behalf of the government, you actually litigated the first case brought concerning the Watergate scandal. Have the various legislative attempts at reform in view of it actually accomplished much? And if not, what does that teach us as to the current situation?" Thank you for wonderful, hilarious, and scorching emails.
Gosh, do I have to say anything at all? I first want to thank the ACS for inviting me here. I am a member of that dark conspiracy that's briefed judges for years, though less on policy and politics than on jurisprudence.
He's having a seminar later today on how you too can be confirmed to the Supreme Court. So any future nominees should want to go to his seminar.
I've worked with a couple who've succeeded, so albeit in more felicitous times. I also am appreciative of the fact that I'm being interrogated by such a fine newspaper man, because I will come to some policy issues, and EJ I've said to him, and he knows, along with people like Michael Barone and Norman Ornstein and Carlin Bowman at AEI, have a good sense of why people are voting the way that they do, and that'll be my ultimate question. But I also want to give a shout out to a gentleman who's been part of my conscience for many years. I come here, you may have some interest in balance, that's not why I come here. I come here for personal reasons. I'd like to have my ideas tested and see if they have any merit. And somebody who's been a critic of mine, a good critic of mine for a long time, is Jack McKenzie, who's
and a former colleague of mine.
One of the great newspaper men, older even than I. So it's true. I did litigate the first Watergate case, and it had to do with the state's attorney in Miami attempting to extradite Maurice Stans to Florida with regard to the infamous check in Watergate, and there's some lessons to be learned there. But my beginning point when I was thinking about this question of what do we do to restore or shore up the rule of law at this time, I recall the time when I was an assistant attorney general during the savings and loan crisis, widely criticized all over the place, and a delegation pretty much from the left insisted on coming to see me to help, and the help that was being offered is something that one, I think, fairly can say is characteristic of the left in Congress, which is to pass more laws. So the question was put to me, we have this savings and loan crisis, and I said, well, you know, a lot of it has to do with economics. Congress never really understood risk when they were deregulating, but kept insurance in place, and I didn't want to hear anything like that. We need more laws. And they said, what can you give us? What would you like to see? What would be another arrow in your quiver that would do the job? And I couldn't think of anything, and I kept getting pressed. I said, we have good laws. FIREA had just passed, mail fraud, wire fraud on the criminal side. We were succeeding in significant measures on the civil side, recovering money, and I just kept getting pressed on this. And finally, I said, well, okay, how about the death penalty for savings and loan kingpins? Somebody wrote that down. To be serious about it, our problem isn't that we need more laws, it's that we're not enforcing adequately the laws that we have. The Watergate defendants, but for one who never should have been indicted, in the first place, all were convicted and sent to jail. So were a number of savings and loan criminals. In the current instance, I got a memo. I'm very popular on the left now, besides perhaps surprisingly to you on the right. I get a lot of fan mail, and I get proposals for what? For legislation. And I got a long list the other day of things that the Democratic leadership might like to see, and it seemed to me that about 80% of them talked about things that already were against the law and just required better enforcement. But one I take from that and urge is mandatory reporting by campaigns and candidates of any contact with foreign citizens or foreign corporations. That seems to me to be entirely reasonable. A touch point for this discussion, at least as it was presented to me, is the analog to Watergate is the Mueller report. And indeed, I think it's, though I haven't talked to him about this and don't expect to, I think that in many ways, Bob Mueller, who I think did an outstanding job, patterned his response as to that of Leon Jaworski at the close of the Watergate investigation, and laid out, in essence, a bill that can be acted upon. And I'll come to Congress in a second. That's my ultimate point. But to me, the most significant part of the Mueller report, and one that cries out for action, some of it legislative, but policy, and it's relevant to what EJ does, it's relevant to what Jack McKenzie made his life doing, informing the public truthfully. The most essential part of the Mueller report to me is the discussion of the threat, in that case posed by Russia, to our election system. Not in the way that it's most often spoken about in terms of ballot security and the physical conduct of elections. That's important, and it's a soluble problem. In fact, it's being solved. The only real barrier to it is that the states are overwhelmed by Medicaid costs and other things. They don't have enough money to do this job well, and so there needs to be some reallocation. But it's the other part of it. You know, we have data breaches, and especially on the left, not unreasonably, there are calls for enhancing privacy, and it's hard to know what privacy means, because, you know, to me, privacy always was the going back to NAACP against Button and cases like that. Privacy implied anonymity, but of course, anonymity is the weapon that has created a truly disgusting internet in many ways. A harmful and hateful internet in many ways, but yet that's a function of privacy. But we can deal with that other ways and at other times. What I'm interested in is the manipulation of public opinion through the creation of erroneous stories as if they were news. That is the political strategy of at least two of our four main cybersecurity adversaries, and the Mueller report with respect to Russia makes it clear how it works. We have people since we're polarizing both on the left and the right, we have people who are willing to believe almost anything if it matches their preconception and fears and prejudices. And that is the thing we need to attend to. This problem can only be solved by a public-private consortium. Recently, the administration created an office within the Department of Homeland Security called CISA. Hopefully it can work. The government is somewhat schizophrenic with respect to the enforcement of cybersecurity, especially on the left, but also to some degree on the right. There's a desire to strengthen the Federal Trade Commission and increase fines for breaches and do a whole host of things that really are not resulting in the diminution of breaches, which are increasing. But if we're ever going to solve the ultimate problem of what the Russians and Chinese in particular are doing with the masses of data that they're accumulating about us, about all of us, and turning that into databases which ultimately are intended to influence and sway public opinion in ways either that are disruptive or which authenticate and substantiate what these countries intend to do, particularly China in the long game. That's who's paying the bill for the PLA to do some of these massive data breaches. I take that more seriously than any other thing that I've read in the Mueller report. You won't hear that from a lot of people who don't work in this field, but if you plumb it, you will. Now let me just spend a couple of minutes, if I have some time left, talking about the border litigation. Larry Tribe and I have known each other since 1961. We have not agreed on anything up until about 6 months ago.
It's wonderful how the president brings us all together.
Well, that's true. I was in a meeting in Milan last week talking about cybersecurity, and in that meeting were 3 people from the People's Republic of China, 3 lawyers from the People's Republic of China, a lawyer from Taiwan, lawyer from Korea, lawyer from Malaysia, lawyer from Singapore, people whose interests often are held to be conflicting. And what are they talking about? Doing deals, exploiting changes in the market because of the great uniter, our president. Trade is a fundamental conservative point, and it's one of the places where not only I, but the farmers of Nebraska differ with the administration. But talking about the border suit, as I have long convinced Professor Tribe, that's not about what our border policy ought to be or our immigration policy ought to be. I think everybody thinks we need a different immigration policy than the one we have. From the farthest left to the farthest right, there's a debate about what it is, but that's not what our lawsuit is about. It's about something a great deal more fundamental than that. It's about the Constitution. What we are trying to do, more than anything, is to both preserve and serve as a stimulus to the Congress in exercising its power. On the left, and I heard it in your opening speech, there's a general desire or belief that the fundamental check on the executive comes from the judiciary. That isn't, the framers would be mystified to hear that. While the courts certainly have a role in checking both the executive and the legislature when they act either inconsistent with what the law says or inconsistent with the Constitution, it's the fundamental job of Congress to be the check on the executive. And yet, and this isn't just a feature of what's going on now, in my own life, I'm 75 years old, going back to the time of the Korean War, there's been a steady erosion of legislative prerogatives. The Republicans, especially in the Senate, are acting like a parliamentary party. The Democrats in the House are acting like a public information agency. They're not exercising the powers that they have, and that's what we're about in bringing the border case. Hopefully, we'll win. I represent the best client of anybody. You know, the Congress case was unsurprisingly tossed the other day on standing grounds, and I leave it to Doug Letter and the lawyers who are representing the House to pursue what they have. But Professor Tribe and I and the organizations supporting us and the many counsel who volunteered to assist us are representing, among other things, the county of El Paso, Texas, where the wall goes right through. And believe me, if we weren't otherwise in relationships, Congresswoman Escobar would adopt me. It's what we're concerned with, and I will take just a second. is the appropriations power. When James Madison talked about energy in the executive, he did not mean torpor in the legislature. And the legislature has got to exert its power of the purse, which is the fundamental power that it has under Article 1 to influence the powers of the executive. In the case of what the president is trying to do, Congress said no to the appropriation that he sought. He's attempting to reprogram monies from other appropriated sources. We believe that's not only unconstitutional, but it's illegal. We're textualists. As I say, we're making very conservative arguments, and I'm pitching it as much to Justice Kagan as I would to Justice Thomas. We don't need other legislation. We just need to enforce the structural Constitution. It's what the framers have intended, and it's what keeps us free.
There's a takeaway quote that any speechwriter or, for that matter, columnist can use. When James Madison talked about energy in the executive, he did not mean torpor in the legislature. That's wonderful. Walter, I'm leaving you for last because you are the Augustine and Aquinas of public ethics, if you don't mind the theological reference. And I wanted to go to Chiara because, in a way, your question, the question you wanted to address, speaks really well to Stuart's point about existing law, whether it's sufficient or not. So why is Michael Cohen the only person in Trump's orbit to go to jail for campaign finance crimes?
Okay, thank you. Good morning. So why is Michael Cohen the only one in prison? At least 3 reasons. 1, the Supreme Court is rebranding corruption. Number 2, the SDNY, which was the entity that prosecuted him, actually cares about enforcing anti-corruption laws like campaign finance. And thirdly, the special counsel was particularly gun-shy about enforcing campaign finance laws, which I think is linked to the first point, that the Supreme Court is destroying the concept of corruption. So let me explain each of those quickly. So I just wrote a book called Political Brands, which will be out in the fall. And in it, I look at different concepts in American political life that are getting rebranded, including truth, tragedy, and treason. And I have a whole chapter on rebranding corruption, which is one of the things that the Supreme Court has done over the past decade. And that matters because corruption is the last state interest that the Supreme Court recognizes as a justification for campaign finance law. And the more they narrow what corruption means, the fewer campaign finance laws will be found to be constitutional, whether they come out of Congress or the 50 states. Another consequence of the Supreme Court narrowing corruption, and they're doing it both in campaign finance and in white-collar crime cases, is that it makes it much harder for prosecutors to actually successfully prosecute a corrupt politicians. Now, corrupt politicians love this, but I think for the rest of us, it's really a tragedy. Secondly, these SDNY, the Southern District of New York, has a long and deep history of actually prosecuting politicians for their corruption. For example, when Preet Bharara was the head of SDNY, they went after corrupt politicians in Albany. And I think he trained his people well. And so when the special counsel spun off the Cohen case to the SDNY, they were ready for it. And so they prosecuted him for several crimes, including 2 campaign finance crimes. And Cohen actually pled guilty to those crimes, which is why he is now in prison. But why didn't the special counsel also prosecute campaign finance crimes? And some of that you would have to ask Special Counsel Mueller. But what I suspect he was reacting to is what the Supreme Court has done in the area of campaign finance, which is to largely deregulate it. And he just didn't want to die on that hill. I think there was an argument that he could have made to prosecute Donald Trump Jr. for receiving or soliciting a thing of value from the Russians, which would be the stolen emails. But he was not going to die on that hill. And you can see that in the Mueller report. He explains that this would be a novel application of campaign finance law, and he is simply not willing to do that. And then there's the question of the individual one status of the president in the Cohen case. So the Cohen sentencing memoranda notes that Cohen didn't do these crimes alone. There was AMI, which is the parent company of the Inquirer, but they get a non-prosecution agreement with DOJ. And then there's individual one, which is the President of the United States, who, according to Cohen, directed these crimes. And there we have the disability that the special counsel was working under, which was he could not indict a sitting president. So all of that, I think, is the explanation for why Cohen is the only one who went to jail. But I would note that there are a number of Easter eggs in the Mueller report, including these dozen ongoing matters. And it's entirely possible that an ongoing matter could well be a campaign finance violation. So in light of all of this, the reforms that I would suggest is, for one, we need to clarify better what a thing of value means for campaign finance law purposes. I would put stolen emails in that category. We need better disclosure so that we end this dark money problem. In terms of money coming from corporations, one of the weird things about that is that corporations do not have to tell shareholders that they're spending their money in politics, nor do they need to get consent from those shareholders to spend that money. So a further reform would be to give shareholders a vote on future corporate political spending budgets. Public financing would definitely help. And then there are reforms that would require amending the Constitution because of what the Supreme Court has done in the area of campaign finance. So if you amended the Constitution to address Citizens United, then you could go back to the days when you could bar corporations from spending in federal and state elections. Or if you amended the Constitution to get rid of Buckley versus Valeo, then you could actually have expenditure limits on rich individuals. So that might solve the Sheldon-Adelson problem. So I'll stop there.
Thank you very much. That opens up a whole series of issues that we need to address. Brevity is the soul of wit. And Shanlin Wu's question was, do we need a special counsel law? Please.
There's a old legal maxim, sounds like it should have come from Confucius maybe, but it's that hard cases make bad law. So we're kind of in an environment at the moment which many of us think constitutes a hard case, without naming anybody. And what that means is if you have an extreme set of circumstances, as EJ alluded to earlier, a lot of our reform laws come as a reaction, some would say overreaction, to circumstances. So it's a natural idea of, well, we have this terrible situation, we need to write a law to fix it. And of course, sometimes you do that and you have bad repercussions from it because you're reacting just to one situation. So if you look at the special counsel law and its predecessor, the independent counsel law, I'd say there are a couple of benefits and a couple of downsides to it. So let's start with the downside. The downside is beware the prosecutor with only one case. Another way of putting that is, to a man with a hammer, everything looks like a nail. You can have a special counsel be too zealous because they're assigned just to look at one issue and they're going to keep looking and looking and looking. That can be a problem. The benefit of it, though, is that they can focus on that. And more importantly, two benefits are you have some degree of independence. And if you are concerned about a cabinet appointee, an attorney general, who may have too much politicization of their views, you have some measure of independence from that. And secondly, you get some public benefit if the public believes that this is a person who's doing their job independently, and importantly, if they're able to communicate their findings to the public, which is ultimately going to be the reform that I'm going to propose. So if you consider what's going on here, if you look at the Mueller report, I think that the part of the Mueller report that is not paid enough attention to, as Stuart indicated, is everything about Russia and the warnings. And the part that is paid a lot of attention to is the obstruction issue. So I'm not going to talk about Mueller's failure to reach a conclusion on the obstruction issue, which is a little bit like saying, Mrs. Lincoln, other than that, how was the evening? But if you look at the report overall, and what is the biggest flack over it is, we can't see it, all the fights over the disclosure. Traditionally, an attorney general has always been able to appoint the equivalent of a special counsel. US attorneys, state prosecutors do that all the time. Particularly sensitive, particularly big case, I appoint my best person to do it. If it looks like there's some political questions to it, they can name a special counsel without an independent counsel statute, without the CFR regulation about the special counsel, well within their discretion to do that anyway. What can we do to codify that? Do we need to codify that? I would suggest the most important thing is, if it's important enough that you want to appoint an independent person, then it's important enough to mandate public disclosure of what they find. And I think if we had that reform, that would make a big difference in what the future brings for special counsels. Again, this circumstance, I think very disappointingly, the current Attorney General is turning out to act a little bit like a political henchman. Apologies, Stuart, he's a friend of yours. But one of the big concerns is, why is he spinning it? Why can't we really talk to Mueller, et cetera? And if there was a requirement that a person in Bob Mueller's position must make that disclosure publicly, I think that could go a long way towards solving some of these concerns.
Thank you very, very much. So Walter, as the designated St. Augustine, I would like you to comment on anything you've heard, and also specifically when you testified before the House Oversight Committee in February, you said that the Office of Government Ethics can ask agencies to conduct investigations and can request copies of records, but it has no power to do anything if they ignore these requests. Does the executive branch ethics program lack an enforcement mechanism? I think the answer to that might be yes from the previous comment, and if so, what's to be done about it? And again, thanks to you and everyone for joining us today.
So I think that, is my mic on here? Can you hear me? I think that the one thing we can say for sure about the ethics program is that the past 2.5 years have taught us it was always more fragile than we ever realized. The thing is, that's not unique to the ethics program. We've seen so many norms departed from in the past 2.5 years, but the ethics program was the canary in the coal mine, and this canary feels like we choked on the toxic fumes of corruption right from the start. And there's a reason it came up in the ethics program first, and that is the first point of contact with a new administration or a new official. For me, the new administration began on November 9th, 2016. I immediately called the Trump campaign that morning, or rather emailed them, and had a brief exchange. We had actually been working with them for months prior to the election. We worked with both campaigns very closely. And so right from the start, we're dealing with them on ethics issues, the president, his nominees, even the structure for how they're going to approach ethics when they come in. And one thing that has been really made clear is how much OGE, the Office of Government Ethics, which I led, was completely dependent on the White House as its primary source of leverage. The ethics program was never perfect, but it worked pretty well for 4 decades until this administration. And it was created as part of a wave of reforms following Watergate. There was nothing in the Ethics in Government Act in 1978 that would have prevented Watergate, but the idea was to strengthen the ethical culture of the government, to try to create a culture in which the kinds of things that led to Watergate wouldn't happen. And again, what would happen is anytime some agency or some official would refuse to do what OGE said, OGE would call up the counsel to the president's office. And as a teeny tiny agency in the government, OGE had very disproportionate access to the counsel of the president's office and wielded that leverage effectively because lawyers generally have tended to be risk adverse, and the counsel to the president's office generally saw itself as there to prevent the president in any administration, Republican or Democratic, from falling into scandal. And so they'd err on the side of calling the agency or calling the agency official for us, and often by the next morning we'd get a call from a sheepish agency official asking us what they needed to do to get in line. That power immediately ended when you had a president who came in and decided not to divest his financial conflicts of interest and to essentially, through the counsel to the president's office, wage a war against the ethics program. This has reached the extreme proportion where just in the past week or so, Kellyanne Conway, senior counselor to the president, went on TV and mocked reporters who asked if she was violating the Hatch Act by trashing other candidates for the 2020 presidential election from the White House grounds on national television. And her response, of course, was, "You won't silence me with the Hatch Act. You let me know when my jail sentence begins." And this is a person who's been found twice to have violated the Hatch Act, not by some deep state actor, as the president would characterize them, but by a presidential appointee of President Trump, who comes from a conservative advocacy group to the government. But the president completely ignored both her violations and the violations of almost a dozen other, actually I think we may now finally be up to a dozen other violations in the executive branch from high-level officials. So there you have a law on the books, and unlike OGE, that agency that enforces this, called the Office of Special Counsel, but it has no relation to Mueller, actually has the power to conduct investigations and write a report and refer a person to the president for action. And just for context, the default penalty for a violation of the Hatch Act was always immediate termination without exception. It was a single sanction law. They watered it down in 2012 because, frankly, that's draconian and there are a lot of circumstances that don't warrant termination. But it goes to show how seriously this act has been taken. And as recently as August last year, the special counsel went after a career official for talking up Hillary Clinton during 2016 election season and inviting some of her coworkers to come with her to a rally and saying we should all vote for her. This person was forced out of government last August and forced to sign an agreement that they would not work for the government for another 5 years. But Kellyanne Conway and that regional administrator from New York's HUD office are out there saying, the heck with this, the Hatch Act, I don't care if I violate it, I'll do what I want. That is the culture of this administration, and it's what we ran into at the Office of Government Ethics as well. The one time I actually tried to conduct something akin to an investigation is there was a lot of reporting about the White House giving ethics waivers secretly to folks. And so I decided to look into the secret White House waivers. And I wanted to be fair, so I sought copies of waivers from the entire government for the past calendar year. So about 2/3 of the time covered by this request were in the Obama administration. And we made a big deal out of 2 waivers that the Obama administration issued. But we also wanted copies of the White House's waivers. They thumbed their nose at us. They called us and told us they weren't going to comply, and how dare we ask for these records. They dispatched Mick Mulvaney, who's now Chief of Staff to the President, but at the time was only the head of the Office of Management and Budget in the Executive Office of the President. And he sent a letter not only telling us they weren't going to send a response to this, but questioning whether OGE had the authority to collect any documents from any agency anywhere in the government, and he copied every general counsel and every ethics official in the government. So you're talking hundreds of people. This was, contrary to the way the New York Times threw around the term recently, an actual existential question for the Office of Government Ethics, because all my staff did all day long was gather ethics records and review them. And so if we couldn't gather ethics records, we might as well send everyone home. And so I sent a blistering, as one news source called it, 10-page letter with 400 pages of attachments back to Mulvaney, and copied Congress and copied all of the same people he had written to, and added inspectors general. It was the second time I was sure I was going to be fired in that administration. In fact, one reporter told me that they'd already written the story and were just waiting for the trigger to get pulled so they could add the final facts.
Third worst that you triggered today.
Yes, I'm sorry. They ultimately wound up releasing the waivers only because Chuck Grassley intervened. And he intervened because at the end of the letter, I quoted a letter to him, from him to the Obama administration, demanding the release of waivers and making the case for why it's terrible you wouldn't release waivers. And I got the idea from when Chuck Schumer crossed out Mitch McConnell's from line and to Chuck Schumer line and just sent him back his own letter. And so Grassley called over and asked OMB, I'm told third hand, by the way, so I'm not 100% sure I can vouch for this, but reportedly called them and asked them to see these waivers, and they wouldn't send them to him. And you don't say no to Chuck Grassley if you're the executive branch and he wants a document. So apparently a fiery response went back and said, you must release these. Well, the secret of the secret waivers turned out, I don't think they actually had ever issued them. They just were ignoring the rules. And the metadata in the documents, when they finally released these unsigned, undated, and a couple of them explicitly retroactive and a couple implicitly retroactive, the metadata suggested they'd been created that morning, which would be consistent with, and when OGE, after I left, continued to write its report, the White House refused to respond and ultimately just said, we decided that the actions didn't warrant disciplinary action, so we didn't take any and issued a waiver, which is, hasn't been covered in the news, but they basically admitted they were just violating the laws and papering over the ethics situation with phony, unsigned, undated, retroactive waivers, which aren't a thing, by the way. So don't grow up going to government and start issuing unsigned, undated, retroactive waivers. But it goes to show, and this is my big concern, and I think this is similar to something Stuart said, that what you really need is Congress to act and to conduct some oversight. We may differ on, I think, what oversight is appropriate, but I'm shocked that when he entered government with all these conflicts of interest, there wasn't any hearing on how these conflicts of interest were going to endanger the republic. And I'm shocked that when the Democrats took over the House, there hasn't been an investigation of how these conflicts of interest are influencing foreign policy or domestic policy for the benefit of the president instead of the people who entrusted him with power. And I think there's a legitimate legislative function, because I've come to the view that the law does need to change. I initially opposed the idea of a law that would actually require divestiture. I would have preferred the reinstatement of the norm, and I had an idea for how to achieve that. But I'm convinced nothing less than a law will actually achieve that now. Even then, though, I don't think a law will work if Congress won't exercise its oversight authority, because you see Kellyanne Conway scoffing at the Hatch Act, and you see Congress not taking action on that. If a president reinterpreted or wrote exceptions by regulation, because there have to be exceptions, but then blew that up so that the exception swallowed the rule, it's all going to go back to, will Congress act? But I do think a couple things could happen. I think OGE could be given more explicit enforcement power. The statute says OGE can request documents and information, and the government must comply, but it doesn't come with any consequence. And so far, the flow chart this administration's counsel office seems to use is, 1, is it illegal? 2, even if it is illegal, is there any consequence if we break that law? And I think, unfortunately, this is an example where OGE doesn't have any enforcement authority. It just has a law it can point to that says you have to, and OGE doesn't have US Marshals it can dispatch to somebody's home to arrest them if they don't comply. But I do think you could try to create some kind of subpoena mechanism that could then be enforced by a court, which is what H.R. 1 has tried to do, the massive reform bill from the House that the Senate has refused to take up. And I think you could also have a law that required a president to divest subject to reasonable exceptions. I think the third thing you could do is give OGE some ability to actually go and communicate with the Senate and the House instead of having to issue public statements and hope they read them. I gave a speech the day that he refused to divest because I understood that all of OGE's power flowed from the support of the White House and that this was catastrophic to the functioning of the ethics program. And I've been proven to be right over the past 2.5 years. And the next day I got a letter from the head of the Oversight Committee, Jason Chaffetz, demanding that I come up to the Hill for a closed door, transcribed, sworn interview because I had dared to question Dear Leader. And sorry, I'm a little angry about it. So again, I think you can have all the laws on the books, but if Congress won't act, they're going to make an improvement, but they're not going to fully solve the problem. I think the one other thing you could do, though, is create some real investigative authority. If it has to be an OGE, I'm supportive of that. What I prefer is an inspector general that has jurisdiction over the dozens of agencies that don't have an IG, and would have supplemental ethics jurisdiction over politicals throughout the entire executive branch upon referral from OGE. And that would, many of you are too young to remember these, but there were these old 1980s or 1960s movies where they'd show a nuclear missile bunker and 2 different soldiers had to turn the key at the same time on opposite sides of the room, so one crazy person couldn't start a nuclear war. It would take 2 crazy people. And this would actually be a similar check. The Office of Government Ethics has to ask for the investigation, and the IG has to agree to do it. And that way you don't have the danger of, as the president likes to say, political witch hunts, but you do have some investigative power.
Thank you so very much. So this panel has already not violated the classic rule of panels, everything has been said, but not everybody has said it, because everyone had a very different voice and a different set of ideas. We've got 17 minutes, and I got a stack of really good questions here. And I think the best way to proceed is not to have, obviously, if everybody answered every question, we would be in considerable trouble. I have one question I'm going to put on the table. I'm going to read several from this pack. A few are addressed specifically to individuals. Some are more general. When you all see that clock say about 8 or 7, let me ask the rest of them. I just want to put them all out there, and each of you can pick what you want to respond to. My question is a simple one. Well, it's maybe philosophically complicated. It's simple to ask. Jed Purdy, who many of you know, and I had a friendly exchange argument, I guess, on norms, whether norms are fundamentally conservative or not. And this era, I think, reminded us of how much we rely on norms rather than law, because we don't actually want to codify everything. And yet, I think at the end of this period, there's going to be enormous pressure to codify a whole lot more than we used to codify. I'd like any thoughts you have on that, on the costs and benefits of that. This question is a wonderful question. What is something one panel member proposed that you, another panel member, disagree with? So that's fun. Another question, if panelists could snap their fingers and amend the Constitution to, quotes, reform government, and quotes, repair democracy after Trump, what would the 28th Amendment be? That sounds like an exam question. That's from a professor. That's a wonderful question. And I'll just, two others I'll throw out and then go to the rest of the pack. One is, what about structural reforms of Congress, question mark? And lastly, does it make sense for the FBI to continue to be under the DOJ? These are all great questions. Any of you can take them. Who wants to start? And go ahead. And if everybody can be brief, because obviously we got a short time here.
I'll take what is the easiest one of these. I disagree with Shannon with respect to the reporting of what it is that a special counsel does, and I'll tell you why. Notwithstanding Morrison and Olson, I felt that the independent counsel statute was unconstitutional. I was joined by several other individuals who were thoughtful about that, and we convinced the first President Bush to let that law lapse. I had the opportunity to serve as the Attorney General for the first 4 months of the Clinton administration, and among the things that I said to President Clinton, and particularly to his chief of staff, was the independent counsel statute has been troublesome for several administrations. We got rid of it. You made a campaign promise to restore it. You ought to forget that. He didn't.
Did he ever write you a note?
He did write me a note, but not about that. We got along surprisingly well. It's great when you have somebody you can blame for the policies that you know you need to have, but don't want to take the credit for. And that was a very effective relationship. We accomplished a great deal in that period of time, including solving the first World Trade Center bombing and dealing with some other major issues. But the independent counsel statute had been restored, and of course President Clinton was subject to it. And the independent counsel, what makes the independent counsel statute unconstitutional, or made it unconstitutional, in my view, was the fact that the president couldn't fire the independent counsel. But there was a reporting requirement. And how many of you liked the report that Ken Starr wrote? I doubt that many of you did. It transgressed what any normal prosecutor does when she concludes a case with regard to discussing a whole bunch of things. Congress wanted a very elaborate report, everything in it, including the stuff that we'd all agree might be distasteful, came out of the mouths of witnesses, and dealt with issues and I'd say forward-looking. If you looked at it, it would invade the privacy and good name of people who were investigated but not charged. There are a lot of good reasons not to do it. On the other hand, Shannon is correct that there's nothing unique about having special counsel. I used to hire them all the time to deal with foreign cases, things that the Justice Department didn't do with regard to intellectual property, where you need special expertise, the like of that. There's a long history of that, and they're employees of the Justice Department, just special ones. And Bob Mueller was one too. What do you get when the president could have fired Bob Mueller, just as we have a laboratory, to paraphrase Justice Brandeis, to know what happens when a special prosecutor gets fired. It galvanized the Congress. It galvanized Senator Baker and others to to set the stage for President Nixon's departure without having been indicted. I think that's a system that works. I believe in politics. I believe in the electorate. We need a smarter, more aggressive electorate, but that's why we disagree.
I want to have a time of reply. By the way, Jerry, you didn't take as much time as everybody, so you have a right to say anything you want on any question. But just one question out of the audience, just to supplement this, and then you can reply to both. How do you deal with the possibility that a public disclosure requirement for a special counsel will deter the appointment of a special counsel? I'm not quite sure where that comes from, but I thought it was relevant. Anyway, go ahead. But you can respond to the critique here.
I think I can respond to both questions with one suggestion, which is bad special counsels will write bad special counsel reports. And so it's really just a question of making sure you appoint the right person, or you don't need to appoint it in that case. The normal prosecutors, and I have a lot of confidence in career prosecutors, can take care of most of the things.
Wow, that was... Jerry, do you have, on any of these questions, you want to jump in?
Well, I'll answer the question that I wish I was asked, which is, are any of these reforms possible? And I would say, actually, yes. One of the results of Watergate was an invigorated electorate and an invigorated populace. And one of the ways you could measure that is 1 out of 4 letters to Congress after Watergate demanded campaign finance reform. We need to do that now. If that's your issue that you care about, write to your member of Congress, write to your 2 senators. If you're on the hustings with the candidates, I think there are 101 of them now, demand that they—
It's like Dalmatians.
Yeah, demand that they take a stance on the part of this reform that you care about the most. Because if there isn't that public pressure, we've already seen how squishy Congress can be, even after the 2018 election. So I encourage you, use your First Amendment voice and demand more of your elected officials.
I leave my moderator's role for 1 second. Amen. Thank you for that.
Thank you.
Anybody? Yes, go ahead.
On what I would propose in terms of changes to Congress, so besides decreasing the overlap in jurisdiction among the congressional committees, I would increase the power of the minority in Congress such that the ranking minority member of committees would have more oversight authority. So for example, the Government Accounting Office treats the ranking minority member as essentially equivalent to a committee chair in terms of requested investigations, and so I would give, Congress needs to obviously give itself, but give the ranking minority member much more oversight authority. And there are some small examples where if you can get enough votes, so maybe you need the ranking minority member plus some number of other members of the committee to have hearing authority, for example.
EJ, can I piggyback on that? That is a very profound point. And just in legislative affairs, DOJ, this was a really big thing because we would get letters from the minority, which is in effect, if Dianne Feinstein right now is writing the writing the Department of Justice for information or something, it's the ranking member of the Senate Judiciary Committee. This is a significant member of Congress for DOJ's in the oversight of the arc of the Justice Department. But the Justice Department policy is it's not an official request, and they can actually either just not respond to it, which happens sometimes and it's sort of icky, or say, please work with Senator Grassley and like a grown-up make a proper request. So that is a great reform. If I can quickly, EJ, because I think this is a quick answer, on the should the FBI remain in the Justice Department? I
thought that was for you somehow.
I do think that's an unequivocal yes, and here's why. I think we think of the FBI as sort of this super agency because, number one, we've had in history some very high-profile FBI leaders. And I also think we think of the FBI as just sort of bigger or more important than other law enforcement agencies. Now, this is some of my deep insecurity as a former ICE person and sort of envy of the FBI and how they're regarded in American, sort of, in the American conversation. But at the end of the day, it is a pretty straightforward law enforcement agency that reports to the chief law enforcement officer of the United States. So I don't think that's a big deal. Now, I do think you will always have overlapping jurisdiction among law enforcement agencies. FBI and DEA are constantly at odds over drug enforcement, ICE and the DEA, and so on. So that's always going to exist. That's what Congress is for, sound oversight to mediate it. But I do think set aside Jim Comey and set aside Christopher Wray and these, or J. Edgar Hoover or whatever, and just think of what they're actually doing. And yes, they do have intelligence authority, but again, so does the Defense Intelligence Agency. Lots of agencies overlap and do different things, and I don't think the solution is to take FBI out.
I actually was in a position to manage the FBI and agree with you very vigorously. And if I needed an object lesson that validated what I thought, it was Waco, where an agency not under the control of the Justice Department, but with considerable law enforcement authority, acting in bad judgment, not subject to the kinds of checks that we normally have, created a national disaster. And so I think you're demonstrably correct.
Thank you. What I'm going to do, Walter, I want you to jump in because you haven't had a say in this round, but I just want to put several other questions that came up here that are of interest that anyone may want to take. How can unpopular or unknown legislation like the Federal Vacancies Act gain public traction and inspire demands for reform that panels discuss? I like the idea of unknown legislation. A nice explosive one. After President Nixon resigned, President Ford controversially pardoned him in an act that was later applauded for letting the country go forward. If President Trump has committed crimes for which he can be indicted after he leaves office, should the next president pardon him? That you deserve a job in cable television, whoever set that up. That's excellent. This was for you, Stuart, where members of Congress are unfocused on the Constitution, have independent agendas, and are so focused on re-election. How do we make them care about enforcing the law as it exists, as you suggest? What can be done to mitigate this? And lastly, and this is obviously for Ann, what reforms could assist making the U.S. Senate do its duty in a timely way on nominations, both judicial and executive, perhaps deemed confirmation, unless a floor vote is held by a date certain, which is something we discussed all those some years ago. So Walter, on these or any of the earlier questions, come on back in, and then everyone, we have 6 minutes, and I just have this feeling this panel will fill those 6 minutes. So I'll...
Before I go, you still filled less airtime
No,
than the rest of
please,
us. Do you want to
no.
go?
Yeah, no, I still want you to come back.
Okay.
Brevity is the soul of wit. Yeah.
I'm going to take up your initial comment about norms and just say something, even though I think we're in an environment where some new laws are needed badly. When I first started in my career, and particularly when I was a new ethics official, a lot of folks at the Office of Government Ethics, admittedly, I'm ashamed to say, including me, sneered at the idea of normative or values-based ethics for government. And as lawyers, we thought rules are better because they provide clarity and they're enforceable. And I was talking recently with some colleagues about how far we've come from that, and the transformation started well before Trump, where we came around to realize that rules set a floor and norms set something more aspirational and encourage people to go beyond. And I think a real world example of that is Mueller has said that he didn't, in some cases, find enough evidence to bring a crime, and in another one he seems to have suggested he did but couldn't act on it. And the president and his allies are saying, see, not a criminal. Well, not a criminal is too low a standard for our public officials. And so I think it's really important to keep norms on the table and not be so dismissive of them. And for any of the younger attorneys or students in the room, I think it's important to resist what many of my colleagues and I did at a younger age, where we were very rigid and black and white, thinking that rules were the end-all be-all. And I'd encourage people to embrace the idea of norms as an overlay on top of a rule-based system.
But you know, one thing that applies to the two of you, that if I may step into the role of moderator for a moment.
Please.
Fixing the norm of Congress as the check on the executive is something that has to be the end result of the Trump administration, because of the fact that it is now clear that Congress, a Democratic House of Representatives at least alone, cannot compel the president, or they can, but the president won't comply with orders of the House of Representatives. And I do fear that we are reaching or have reached a point where a president can simply just not recognize Congress as a co-equal branch of government that has the authority to either check the president or investigate the president. So I don't know if it's, because I don't know if we were founded on a principle of no kings, and I don't know if the solution is then to create a kingly Congress that has the power to do everything and lock somebody up. But I do think, at least in terms of norms, that's the big one, and I'd be curious to hear both of your thoughts on how we get past that. Because he didn't release his tax returns. That was a big deal, and I think that was a bad norm. But this one, I think, does have the ability to affect how we function as a nation.
Could I ask a quick question right there? I'm just to paraphrase my colleague here. I'm so old that I remember both parties being absolutely on the other side of the executive power issue. And the Heritage Foundation once had a piece called the Imperial Congress, and then they didn't so much believe that anymore, and it went, and you can see it on both sides. What we have with a party system is at odds in a way with institutional patriotism, if I can call it that for my...
That's something relatively new. I mean, the history of American political parties has not been ideological except for several briefer periods within American history. We're moving towards this polarization where it really is becoming true in many ways. I suggest that there's a single issue that's driving all of this, and that has to do with the future of work. That's for a different discussion at a different time, but I urge you to...
That's very democratic socialist
to think
of
about
you,
it.
actually.
No, I'm not talking about socialism at all. I think socialism is a failed doctrine. But one of the great ironies is the fact that a party that has decried the usurpation of legislative authority by the judiciary is now seeking to usurp legislative authority by the executive. I mean,
Well, yes, but you have an executive who's been accused credibly of breaking the
well,
law.
and we agree about that. And so I do want to close at least what I have to say today about norms, which is among the most moving and unifying events that I've ever been a part of in my entire life, was the funeral of George H.W. Bush, a man who was dedicated to normative behavior. When he talked about a kinder and gentler nation, he really meant it. He was a friend to me, but he was a friend to at least 1,000 people in his administration. And the reason why we got jobs is that we weren't looking for jobs, and we were people who he wanted to serve. That's what it takes. Walt Kelly, who wrote Pogo many years ago, had a cartoon where Pogo, with a tear in his eye, is saying, we've met the enemy and he is us. I mean, we need a more active electorate. The question that was posed to me about what do we do about Congress? When I came here 50 years ago, every congressman, even the segregationists, knew issues. They knew something. They might have been nowhere on civil rights, but they knew tax law. They spent their time on stuff. That's now out the window. They spend time on politics and re-election. We've got to elect better people. We have term limits. We don't need to pass new laws. Throw the bums out.
And Chiara, I want you to come in because you're like that actress who keeps herself hidden, and we all want to know more.
Oh, man. So I guess one piece of advice I would give all of us is I think the 2020 election is going to be a bleep show. And it's going to be that way because the lies are going to be coming fast and furious. So one thing I would suggest is if someone appears to be your political opposite online, don't assume they're an American. Don't even assume they're a human being. They could be just an automated bot that is spewing out anger and hopes that you fight back. Don't waste your time on that. Focus on the issues that you care about and urge your favorite politician to adopt them.
Amen.
That's
Applause, yes.
Thank you.
So I want to thank this panel. The reformer is always unhappy because the reforms don't go far enough or they don't work the way the reformer had in mind. The reformer is always criticized because the reforms don't work as intended. And the reformer is always seen as a kind of nudge, a busybody, a complainer. And yet think about democracy without reformers. Democracy without reformers withers away. Without reformers, conservatives can't preserve the institutions they revere, and progressives can't secure the justice they seek. So I just want to thank this panel of reformers and this room of reformers for a really wonderful conversation. Bless you all. Thank you very much.
Thank you.
bless us. Wow.